ready. Ask the chair's permission and then go ahead.
Yes, sir. So maybe begin?
Yeah, please.
Yes, sir.
Share screen.
Sir, we'll begin now. A very good morning to our esteemed panelists and the participants who've tuned in this early on a Sunday morning. Also, a very good evening to Ms. Kathy Catterson, who joins us all the way from the USA. I'm Akshat, joined by my colleague Sumedha from the Foundation for Democratic Reforms. We welcome you to the second edition of the Indian Democracy at Work conference on the topic Rule of Law. Over the last week, we have witnessed extensive deliberations by subject heavyweights on some of the most pressing issues of our times, from addressing the challenges of policing, strengthening our investigation and prosecution, to reforming both the civil and criminal procedural code and ensuring speedy justice in our trial courts. The topic for this particular session is strengthening the role of constitutional courts. The session will focus on reinforcing the role of the High Courts and the Supreme Court as constitutional courts. We will discuss the issues of clearing pendency in the High Courts and establishing permanent constitutional benches. By the end of the session, we hope to arrive at mechanisms to reduce dependency in High Courts and an architecture for strengthening constitutional courts in dealing with substantial questions of law. To enlighten us on the issue, we have with us a distinguished panel consisting of some of the tallest names in the field. First, we have the chair of the session, Justice Madan B. Lokur. He is currently a judge of the Supreme Court of Fiji and is a former judge of the Supreme Court of India. Justice Lokur is also the former Chief Justice of the Andhra Pradesh High Court and the Guwahati High Court and a judge of the Delhi High Court. He is known for presiding over matters of social justice, earning his bench, the Social Justice Bench moniker. We welcome you, sir. Next, we have Ms. Kathy Catterson, who is the former circuit executive of the Ninth Circuit, USA. Previously, she held the post of Clerk of Court as well as Court of Appeals Executive of the Ninth Circuit, USA. She oversaw almost 300 employees working in multiple courthouses along the West Coast and helped develop solutions for managing the Ninth Circuit's heavy caseload. We welcome you, ma'am. Next, we have Shri V. Sudhesh Pai, a distinguished lawyer and jurist and an acclaimed author. He has been visiting chair professor Ashutosh Mukherjee Chair in West Bengal National University of Juridical Sciences, Kolkata, and is a resource person at the National Judicial Academy, Bhopal. He has also been a senior research scholar at the Karnataka Law Commission. We welcome you, sir. Finally, we have Shri Alok Prasanna Kumar, who is the co-founder and lead Vidhi Center for Legal Policy, Karnataka. As a lawyer, he has practiced in the Supreme Court of India and the Delhi High Court from the chambers of Mr. Mohan Parasaran. He co-hosts the Ganatantra podcast on IBM Podcasts. His areas of research include judicial reforms, constitutional law, urban development, and law and technology. We welcome you, sir. I would like to take this opportunity on behalf of the entire Indian Democracy at Work team to sincerely thank our panel for taking out precious time from their busy schedules and gracing this occasion. We would also like to thank Dr. Jayaprakash Narayan for showing us the way and leading this initiative. Now, before we begin, we would like our participants to keep in mind the following. The session will begin with a 5-minute presentation from FDR. Then, the chair for the session will first present his views for 10 to 12 minutes. The chair will then call upon each speaker, who will also have 10 to 12 minutes to share their insights. Post that, the chair may open the session for a panel discussion. The last 30 to 35 minutes will be dedicated to taking questions from the audience. We request the participants to keep the questions brief and lucid and also mention the panelists that they would like the question to be directed to. The questions can be put in the chat box. Since we are also streaming the event live on YouTube, those tuning in from there can put their questions on the YouTube chat. In case any technical glitches arise, be assured that they will be resolved at the earliest. Thank you for tuning in, and I hope you all have a fruitful and engaging session. I would now like to invite my colleague Sumedha to take charge of the proceedings. Over to you, Sumedha.
Thank you, Akshat. A very good morning to everyone and good evening to Ms. Catterson. Constitutional courts. Courts with the authority to interpret, enforce, and otherwise act as the guardians of the Constitution. The High Courts and the Supreme Court are entrusted with this solemn responsibility, but they are currently struggling to discharge their constitutional functions owing to their ever-expanding court dockets. Mounting arrears in the High Courts is perhaps the greatest challenge confronting the Indian judicial system. But it is not one of recent origin. An expert committee to study and suggest means of lessening the burden on the High Courts was constituted as far back as in 1949. Ever since then, there have been numerous committees and law commission reports that have suggested several recommendations, ranging from restricting the jurisdiction of the High Courts to increasing their judicial strength. While some of the recommendations have been adopted over time, the burden on the High Courts is only worsening. There are now more than 5.6 million cases awaiting a final decision in the High Courts, out of which 80,000 cases have been pending for more than 3 decades, as can be seen in Figure 1. The enormous caseload means that over 8,000 cases are pending on average per High Court judge. Placed at the top of the judicial pyramid in a state, High Courts exercise a diverse jurisdiction spanning ordinary, extraordinary, original, appellate, and revisional jurisdiction, in addition to their constitutional writ jurisdiction. Appellate and revision matters alone account for 40% of their caseload. Moreover, a High Court has the power to punish for contempt of itself as well as for contempt of its subordinate courts. High Courts are further responsible for the supervision and administrative control of trial courts. Given the heavy caseload and vast responsibilities, Indian High Court judges are arguably the most overworked judges in the world. Clearing the existing backlog of cases is a prerequisite for any further action to strengthen the High Courts. Drawing from the yet unimplemented recommendations made by several expert bodies in the past, we propose that a four-pronged strategy may be adopted for clearing the backlog. First, by filling up the vacancies in judicial positions on priority. As depicted in Table 2, High Courts are currently functioning at only 60% capacity. Second, by appointing ad hoc judges from amongst retired High Court judges under Article 224A to clear the backlog. Third, by limiting the jurisdiction of the High Courts. First, by abolishing ordinary original civil jurisdiction for the 6 High Courts that continue to exercise the same. It is a remnant of the colonial times, and there is no justification for its retention with the establishment of the city civil courts in each of these metropolitan areas. As can be seen in Table 4, High Courts in fact take longer to dispose of these cases and are therefore less efficient as compared to their corresponding trial courts. Second, by limiting the scope of appeals in 2 ways. 1, increasing the pecuniary limit of appellate jurisdiction of district courts and mandatorily reviewing these limits at regular intervals, say every 3 years. And 2, by restricting the second appeals in civil matters to suits above a certain limit, say rupees 2 million, or in other words, rupees 20 lakhs. Third, by restricting revisional jurisdiction. Civil revisional jurisdiction may be abolished as Article 227 of the Constitution provides sufficient remedy as recommended in the 54th Law Commission report. On the criminal side, High Courts should have the power of revision only against orders of sessions courts or special courts. And the final strategy entails expanding the judicial clerk system, which is in its infancy in India. Each High Court judge must have a minimum of 4 clerks selected purely on merit. Prospects for career growth for judicial clerks must be enhanced, similar to the system in other major democracies. The Supreme Court, the highest court of the land, is facing a crisis of a similar nature. The Constitution envisages several diverse roles for Supreme Court. The exercise of its discretionary jurisdiction over the years has led to an expansion of its appellate matter caseload. As a consequence, a considerable portion of the court's resources are being spent on dispute resolution functions, and constitutional adjudication has taken a backseat. It is particularly telling that in 2014, only 7% of the judgments delivered by the Supreme Court pertain to constitutional matters. Even worse, the number of matters heard by the constitutional benches has reduced from 15.5% in the 1950s to 0.12% in the 2000s. Besides the quantitative aspect, constitutional adjudication is increasingly getting delayed, often taking years for a final decision. Establishment of a separate and permanent constitutional bench is therefore essential to preserve and strengthen the constitutional role of the apex court. Similar recommendations have been made in the past at various points in time, especially by different law commissions. Article 130 of the Constitution allows for such a restructuring without the need to bring about a constitutional amendment. A permanent constitutional bench will not only serve to restore the constitutional role of the court, but also qualitatively enhance constitutional adjudication by reducing the scope for conflicting decisions by different benches of the court, providing clear and unequivocal guidance for the rest of the courts in the country. On that note, I conclude our presentation. I now request the Chair, Justice Madan Lokur, to give his introductory remarks and facilitate the discussion. Over to you, sir.
Thank you, Sumedha. That was an excellent introduction to the discussion that we're going to have. And welcome to all the panelists and all the participants who are here today. Briefly, as a sort of a background, we have a 3-tier structure in our justice delivery system. You have what are called the district courts, right? That is, in every district you have courts. Then you go up the ladder, you come to the High Court, which is in every state. Every state has a High Court. And then you go further up the ladder, then you have the Supreme Court. So it's really a 3-tier system that you have in our justice delivery system in India. Now, the crisis that is facing our justice delivery system actually is starting from the bottom, from the district courts. But that's not the subject of discussion today. The subject of discussion today is about the constitutional courts, which is the second level, that is the high courts. And then you have at the apex level, you have the Supreme Court. So I think we just concentrate on these two, that is the high courts and the Supreme Court. Now, we have been given a wonderful background by Sumedha. My view is that let's start at the Supreme Court. That's how I would look at it. And there are two aspects to justice delivery. One is the aspect of the judicial, cases, or the cases that are being decided. That is one aspect. The second is the administrative aspect, or the registry. How does it work? Is it working well enough? What about the judges? Are they getting the necessary support that they require from the registry? That's the second aspect. Now, so far as the first aspect is concerned in the Supreme Court, my view is that, we all talk about too many cases coming up in the Supreme Court. It has perhaps gone up to about 6,000. We also say that, the government is the biggest litigant. Well, that's anecdotal evidence, I suppose. What is the exact number of cases where the government is the litigant? One really doesn't know. But I would assume it to be correct that the government is the biggest litigant. Now, when we talk about the government, we talk about the government of India, and we talk about the government of the states. So my first suggestion in this regard is that really the Supreme Court should be in the nature of a federal court. That is to say that it should deal only with cases which have an all India impact. Okay, now you have, for example, the Indian Penal Code. It has an all India impact. You have laws made by Parliament. They have an all India impact. So really the Supreme Court should be concerned with cases that have an all India impact, and of course, constitutional cases, no doubt about that. But they should not get into cases which relate to laws or interpretation of laws of the states. For example, you have, say, the Delhi Rent Control Act. Now, who are the people who are interested in an interpretation of the Delhi Rent Control Act? It's only the people of Delhi, the people of Maharashtra, or the people of Karnataka. They're not concerned with, the Delhi Rent Control Act. Similarly, you have the Bombay Rent Act or the Karnataka Rent Act. I don't know what it's called in Karnataka. But the people in Delhi are not bothered about it. People in Bengal are not bothered about, what the Karnataka Act says. So let's limit the jurisdiction. It's a matter of self-restraint. Say that, well, if it's a state law, let the state decide. Let the High Court of the state decide. And we are not going to interfere in cases pertaining to state legislation. That is, cases which fall in list 2 of the 7th schedule of our constitution. But yes, those cases which involve the entire country, which parliamentary laws, for example, yes, certainly, if there is a need to interfere, the Supreme Court will interfere. That is one. The second is the filtering process. Now you have, under the Constitution, you have, grant of special leave. That is 136, Article 136 of the Constitution. Every case is filed under Article 136. But then you also have provisions for the grant of a certificate which is given by the High Court. Well, it's an important question of law that requires to be decided by the Supreme Court. So therefore, we grant certificate. That provision has not been used for many, many years. Maybe there are 4 or 5 cases in the last maybe 25 or 30 years where the High Court has granted have granted a certificate for leave to appeal, but it's not being used. So you have a filter which is there in the Constitution, but is not being used. So if you take both these together, limiting the jurisdiction through a process of self-restraint only to federal laws, parliamentary laws, and utilizing the filters that are available in the constitutional scheme, perhaps the caseload of the Supreme Court will come down drastically. Okay, then perhaps only the government of India might be the biggest litigant, but certainly the governments of the states will probably not be coming to the Supreme Court except in very, very rare cases, if at all. That's the judicial aspect. Second is the administrative aspect. I believe we need to strengthen the administration of the Supreme Court, the registry. That needs to be strengthened. In Canada, for example, I have had occasion to meet the registrar of the Canadian Supreme Court. At that time, it was a lady, and she was appointed by the Canadian Parliament and was answerable only to the Canadian Parliament. She was not answerable to the Chief Justice of Canada. So if the functioning of the court, the administrative functioning of the court was not up to the mark, so to speak, Parliament would pull her up. The Chief Justice had nothing to do with it. Now we need something like this, maybe a hybrid sort of a system where there is independence that is available to the registry. The registry is not, on a day-to-day basis required to consult the Chief Justice of India. So it must have that independence. It must have that professionalism that is there. Administrative functioning or administration or governance is not something that you just pick up while walking on the street. You have to be trained for it. So that is I think very, very important, so that we don't have issues of cases not getting listed, some cases getting listed, some cases lying dormant for years together, and so on. That's about the Supreme Court. Now, so far as the high courts are concerned, well, there are again a few suggestions that I have. One is, yes, we need to fill up the vacancies. 40% vacancies is pretty high. Okay, but then we are in some sort of a vicious circle because there are so many cases pending. Therefore, we need more judges. Because we need more judges, we create more vacancies. Because we have more vacancies, we are not able to appoint so many people. We are not able to appoint so many people, so the number of cases are rising. Cases are rising, so we need more judges. So we're just going around in a circle. So at some point of time, we have to very seriously think about implementing the judgment of the Supreme Court on the question of filling up vacancies, and make sure that it's like a mission mode project. Let's do it in 1 year. Let's do it in 2 years, and be done with it. 40% vacancies are, of course, out of the question. You need stability for appointment of judges. You can't have judges being, at the whims and fancies of whoever, effects those transfers. You can't have judges not being appointed to a particular court, but being appointed to another particular court for some whatever reason. Right? You can't have the government sitting on the recommendations of the Supreme Court and the High Court for the appointment of judges for days together, months together. So these are inherent problems. Second, the high courts of the state should be the equivalent of the Supreme Court of the state. So they should be the final authority in the interpretation of the laws pertaining to the state. So the Delhi High Court should have the final word on the interpretation of the Delhi Rent Control Act. Karnataka High Court should have the final word on the interpretation of the Karnataka Rent Control Act. Guwahati High Court should have the final word in the interpretation of the Assam Land Reforms Act, for example. So once you do that, automatically, I think there will be a great deal of responsibility on the judges to, think carefully and arrive at a decision. And there will be this finality, and therefore a lesser number of cases going to the Supreme Court, assuming that Supreme Court does not interfere in state laws. The third really is to tone up the administration. I've already said that about the Supreme Court. I think it's the same thing with regard to the high courts as well. Tone up the administration, improve the registry. The final point in this is to conduct some sort of a cleanup exercise. Sumedha told us that there are 5.6 million cases. I don't know what is the correct figure, because this morning I checked up on the e-courts website. The figure came to 4.81 million. So there is this gap of 600,000, which is quite a lot, or 60,000, whatever. It's quite a lot. But there must be this cleanup exercise. Many of these cases which are 30 years old, for example, nobody is perhaps interested in them. Carry out, a sort of a housekeeping or a spring cleaning sort of exercise, and get rid of all these, miscellaneous cases which are just pending for years together. That by itself will reduce the load. It's going to take an effort. The Supreme Court had done that in the late 1990s. I'm sure the high courts can do that and get rid of a lot of, junk, if I may say so, junk litigation. So these are my few opening remarks. May I now request Mr. Sudesh Pai to, give his opening remarks. Thank you.
Thank you, Judge Saab. I consider it a great privilege to have been invited to share my thoughts this morning, because the topic that we are talking about is indeed very serious concern to all of us and to Indian democracy itself. It has been emphasized time and again that the function of the superior courts, the constitutional courts, is to uphold constitutional values and enforce constitutional limitations. This is of the essence. And the ultimate guarantee for achieving this is the personality and intellectual integrity of the judges of the superior courts. So Justice Madan Lokur has given us an excellent opening presentation, and I can add very little to what the learned judge has pointed out. I would only say that it is important to remember that the role of the constitutional courts is not so much dispute resolution, deciding cases between parties, as developing law and jurisprudence, identifying and defining principles or nuanced principles on existing platforms. I believe this is the primary role and function of the constitutional courts. Deciding inter-party disputes is perhaps incidental and secondary. I think this is something that we have to keep in mind when we talk of this topic. Now, judicial exegesis is inevitable in expounding the Constitution. And it's a neat balancing act where judges should be careful not to erect their own prejudices and principles into constitutional principles. At the same time, the Constitution is a living charter. It can't be embalmed in the ideas and habits of 1950. So this is a kind of a neat balancing act. And it is here that the personality of the judge is very important. Now, the Supreme Court occupies a very preeminent position. I'm afraid whether that preeminent position has been diluted over the years for various reasons. Justice Lokur pointed out, and I very, very respectfully agree, that the high courts must be strengthened and their preeminent position in the state has to be restored if that is lost. I think in the earlier years, the high courts meant really the supreme authority in the states. Today, unfortunately, maybe because of the expansive exercise of 136 jurisdiction, every matter is taken up to the Supreme Court, and that is one of the reasons for all our problems today. But 136 cannot be restricted by any enactment. It is to be done by self-restraint. The filtering process has to be very strictly employed. Now, what has happened is the Supreme Court has, in a way, converted itself into a general court of appeal by self-enlargement of its jurisdiction. Most of the court's work, unfortunately, is confined to disposing of special leave petitions by judges sitting in benches of 2 or 3. And added to this, you have the contribution from Parliament, where the Supreme Court is designated the first appellate court in very many matters. And the net result, unfortunately, is the court has no time for serious constitutional work for which the court is meant. Even presidential references under 143 wait in the queue for a long time. The Constitution envisages the Supreme Court, though at the pivot of a hierarchy of courts, not so much as a general appellate tribunal, but a constitutional court to decide matters of great importance, constitutional interpretation, and laws touching the entire nation. As Justice Lokur pointed out, it should really be a federal court, not dealing with questions of law arising from different parts of the country and affecting very few people. And again, it is not uncommon that even 2-judge benches sometimes decide and pronounce on constitutional issues. That, I'm afraid, is not a very happy thing. The Constitution has envisaged a minimum of 5 judges. Of course, that was when the court consisted of 1 plus 7, the Chief Justice plus 7 judges. Today, the strength of the Supreme Court has increased manifold. It is really a question to be, I just throw open this idea. Justice Subbarao, Chief Justice Subbarao had said that the ideal strength of a Supreme Court should be 11. Perhaps there is much to be said about that. I'm not talking of the pendency and the number of judges required, but the Supreme Court is an institution with that small number of judges would perhaps be a more coherent body. Justice Matthew perceptively said, to say that no litigant should be turned out of the court so long as his grievance may be a good populistic propaganda, but the consequences of accepting such a demand would surely defeat the grand purpose of the court established under the system. And Justice Bhagwati, in the Bihar Legal Support Society case, very aptly said that the Supreme Court was created for the purpose of laying down the law for the entire country, The extraordinary jurisdiction of granting special leave conferred by Article 136 is so that it could interfere wherever it found the law was not correctly enunciated by the lower courts or tribunals, and it was necessary to pronounce the correct law on the subject. Now, this pronouncement of the correct law on the subject, again, as Justice Lokur pointed out, should perhaps be restricted to laws affecting the entire country, or in very rare cases, maybe where it could be even state laws. But that is a very wise judicious discretion which the judges of the Honorable Supreme Court must exercise, and 136 should not be very freely used. It has been suggested quite too often that the court should have a regular constitution bench sitting to decide constitutional issues. The suggestion bears repetition because of the urgency and importance of the problem. Of course, one suggestion is, of course, very common, but that is again a vicious circle to increase the judge strength. Increasing the judge strength of the Supreme Court, I believe, would cease, that the court would cease to be a compact, coherent institution. Of course, Justice Krishna Iyer, in his inimitable style, said that Parkinson's law would generate more work, and a crowd of robed brethren is chaos in the cosmos, while a brilliant batch with a sharp grip on the backlog makes all the difference. Of course, this is Justice Krishna Iyer in his inimitable style. But it is necessary that the Supreme Court particularly, and the high courts no less, because the high courts are the constitutional courts at the apex of the state level, and it's important that they discharge their constitutional role as much. The civil appellate jurisdiction, the criminal appellate jurisdiction are no doubt important, but the constitutional courts envisaged by the Constitution have a separate, distinctive role which cannot be lost sight of in the process of our anxiety to dispose of cases. Of course, disposal is important. I don't think anyone could say disposal is not important. But disposal by itself, I believe, is not the solution. It is not only quantity, but quality that is absolutely important, and that too at the level of the high courts and the Supreme Court. The Supreme Court cannot just be a court of error to correct every mistake that happens in the lower judiciary. Of course, unlike in the civil law countries, we are a common law system, and in the civil law, as we know, that the highest court sits in different divisions, so much so that the impress of the personality of the judge is not there on decision making. But while structurally we need not be divided, functionally the Supreme Court can constitute itself into a constitutional division where you have at least one, or I would even submit two permanent constitution benches which deal with the serious constitutional business, while the other judges can deal with the civil and appellate and criminal work. And these judges would rotate so that it's not as if someone is permanently a part of the constitution bench, someone is permanently part of the, after all, Supreme Court is one court and all judges are judges of the Supreme Court. And maybe by rotation, they could do the work on the constitution side and the other benches. And it is also important that in the common law, the appointment of a judge of a higher judiciary is the announcement of an emerging judicial personality. So the impress of the judge on constitutional issues is important in our system of justice administration. I don't know whether specialization is a good thing or not so good a thing, whether we could have judges for specialized work in the high courts and the Supreme Court, so that perhaps it may quicken the pace of disposal to some extent. If you're familiar with a subject, you would definitely be able to deal with it better and quicker. Ad hoc judges, I think, is a very good suggestion. And we had in the Supreme Court in the 50s, two of our greatest judges who did excellent work as ad hoc judges, Justice Vivian Bose and Justice Venkatraman Iyer. being sat after their retirement, and perhaps ad hoc judges would also not be burdened with administrative work. They could concentrate fully on the judicial work. And I think later in the 1990s, Justice Jayachandra Reddy, as an ad hoc judge, disposed of a large number of criminal matters. And well, you have examples like that. So ad hoc judges, I think, is a thing which, but unfortunately, in the high courts, we have hardly had ad hoc judges sitting, though the constitution makes provision for that. It would be a good thing if that provision is used even in the high courts. Now, this restricting the revisional jurisdiction was mentioned. It's good, but then I do not know, even though section 115 CPC has been taken away, article 227 steps in, and perhaps the number of cases are virtually the same. So whether anything has been achieved by restricting the revisional jurisdiction, or is it just converted to another supervisory jurisdiction under 227, is something that bears examination. Once we strengthen the high courts, as Justice Lokur also pointed out, to a large extent, the work of the Supreme Court would get reduced. Of course, all this would, if I may say so very respectfully, require that you have the best people to man positions in the superior courts, because that is another topic altogether. You need judges of competence, quality, and character. In fact, I'm tempted to, with this I'll close, I'm tempted to refer to Mr. Venugopal's R.K. Jain Memorial Lecture long ago. And Chief Justice Dixon said that the judges of the highest caliber are necessary to man the superior courts, possessing integrity, equanimity, legal knowledge, patience, and common sense. And Mr. Venugopal said the Supreme Court should have a separate cell which would analyze judgments of each High Court judges for the purpose of finding out the quality of their work, and that would disclose whether he has statesmanship, legal knowledge, experience, and balance. If all these are present, the inputs of each of the Supreme Court judges would ensure a meaningful and effective decision in the cases before them. And if this is done, one can look forward to a glorious future for the court, where judges will be able to listen to arguments with detachment and patience, devote themselves to reading legal classics, ponder over arguments, and deliver celebrated judgments. I sincerely wish that this comes true, not in the faraway future. These are some of my thoughts which I share with you, more for your consideration. Thank you so much for this opportunity. I hope I have not exceeded my time.
No, thank you, sir. Thank you. May I now request Alok Prasanna Kumar to make his opening statement, so to say.
Thank you, Justice Lokur, and good morning to everyone. It's my pleasure to be on this forum talking about this issue. Let me very quickly put up a few notes that I have prepared based on also what I've just heard and Mr. Sudesh Pai's informed remarks on this matter. I would like to start by questioning this idea of what are constitutional courts. I think we shouldn't treat only the High Court and the Supreme Court as constitutional courts, because to me, the district courts and down to the last magistrate are constitutional courts. If you look at Article 22, the magistrate has been given, I think, by far one of the most important powers under the Constitution. That is to see a detenue within 24 hours of that person being detained. Not a detenue, but any person being detained within 24 hours by being taken to the police. And we have just seen a live example of what happens when a magistrate does not do their duty in this regard in the Disha Ravi case. First, that Disha Ravi wasn't produced before the local magistrate. And secondly, the magistrate in Patiala House Court simply did not apply his mind to the situation, as has been brought out by the judge who granted her bail. So in my view, we should not consider only High Court and Supreme Court as constitutional courts in terms of whether the Constitution provides for them, in terms of whether they perform important duties. We should also consider them. Interpreting the Constitution is important. So of course, I will focus my comments on the High Court and the Supreme Court. I don't want to drag discussion too far away from what is the scope of our discussion. Some of the points that I wanted to make have already been made. I think we have seen serious, this has been made in the initial presentation. So I will not report, I will not go through them. But for the high courts, first I'll talk about the high courts and then I'll talk about the Supreme Court. In the High Court, Sumedha has already gone into some of the data. Justice Loco has also gone through some of the main points. But I'd like to highlight about 6 causes for some of the problems that we're seeing with the High Court. The first that we are seeing is that there is a sense of, there's a bureaucratic intransigence towards court orders, prompting the repeated filing of contempt petitions. This is a phenomenon that we at Vidhi realized when we were studying the Jammu and Kashmir High Court. A lawyer put it very beautifully for us in Kashmir. They said when we file a petition in the court, we also file a contempt. We also keep the contempt ready because we know it is not going to be complied with any reasonable time. So what you're doing is you're duplicating. Now, writ petitions are a huge part. They are constitutional jurisdiction of the court, and you have the bureaucrats simply not implementing court orders, and nobody's asking them to like change laws. It's like just do as we direct, and we find a high level of bureaucratic intransigence which does not seem to have any consequences. Second cause for these problems we sort of identified through our research is that high courts are too concentrated in the major cities of a state. If I were to take Karnataka's example, and this is a state which we studied in our research, 50% of Karnataka's writ petition cases come from one city, which is Bangalore. Now, Bangalore is an important city. It's an economic hub, very large population. No one disputes that. But if you're going to have a part of the state which has about 15% of the population, maybe 1/3 of the economy, contribute to 50% of writ petitions, it tells you there is an imbalance. Other parts of Karnataka do have benches, but these benches don't seem to be serving the purpose because the number of cases filed before them are fractional. In fact, the parts of Karnataka where you need such a bench don't seem to be getting those kinds of benches at all. What I say for Karnataka is also true for the state of Uttar Pradesh, which is huge. It's also true perhaps for Rajasthan, also true for Madhya Pradesh, perhaps West Bengal as well. Now, any state with about more than 50 million people, I think should have a minimum of 3 to 5 circuit benches. A fourth point that I want to very quickly make is that criminal appeals are slowing down the High Court system. Now, this is a matter which the Law Commission has taken up. I will not take too much time to talk about it, but we don't seem to be able to get criminal appeals disposed of quickly in our High Courts. A fifth point that I want to make, and it's something which goes back to what I just mentioned, a lot of bail cases are filed unnecessarily in the High Court because the sessions judge simply refuses bail. Now, this is Justice Atul Sridharan of the MP High Court recently said this in a speech. And he pointed out, and this was separate from the case of Munawar Faruqi and his associates, there is an immediate reaction of judges to deny bail. They don't want to take responsibility. They feel that if we grant bail, we are seen as too quote-unquote liberal. Suspicions are raised against us, must have taken money to grant this bail. So safest course of our action, simply deny bail. Let the High Court grant bail if it wants to. He has said this in the context of MP High Court, and this has made me want to study the matter. But from my own experience and from having spoken to a lot of lawyers, there is a tendency in especially high-profile cases to simply deny bail and let the High Court take care of it, adding to the High Court's burden. Finally, I want to raise one point about the High Courts, which is that there is a bias towards appointment from the bar than the subordinate courts. I have looked at the data and I published a study in the Economic and Political Weekly a few years ago. The Supreme Court has generally followed a practice, has suggested that, at least, and I say the word at least with meaning here, at least 1/3 of the appointees to the High Court should be from the subordinate judiciary. Unfortunately, what has happened is that this 1/3 has become a ceiling. It is not a floor, it has become a ceiling, which has meant that 30% of High Court judges are only from the subordinate judiciary. What does this mean? Those in the subordinate judiciary feel that, we don't get any career opportunities. But also here is a ready pool of thousands of fairly interested eligible candidates that the High Courts are not tapping. Now, one response that I get when I make this point is that, but they're not of good quality. To which my response is, who's the person responsible for raising the quality of judges at the subordinate judiciary? It's the High Courts. It's a failing of the High Courts that you say that the judges are not very good. Justice UL Bhatt in the Madhya Pradesh High Court actually identified good judges and said, look, I know you have room to improve, but I think you're good enough. I'm going to spend 2 years working with you to ensure that you are raised to the quality, your standards are raised to the quality of what is suitable for the High Court, and appointed about 8 out of the 10 of them. This is something that he mentions in his autobiography. So I think the raising the quality of subordinate judges is something that should also be considered. When it comes to the Supreme Court, I sort of identify about 4 problems. Most of them have been already mentioned, so I will not repeat the 2 of them, but I want to sort of highlight one problem. Actually, 2 problems. One is that you have far too many cases heard by 2-judge benches with very little consistency. You have, Mr. Sudesh Pai mentioned it, I won't labor that point. But I want to highlight one thing which is not spoken of enough, which is that the average judge spends too little time on the Supreme Court of India. I ran the numbers and we found that the average judge spends 3.5 years on the Supreme Court. That is nowhere enough. Because about 2 years of that is spent as a puny judge, where they don't really supplement the efforts of the senior judge. Now, these are all judges with about 20 years worth of judicial experience. And I honestly believe that their capacity, training, and talent is wasted by making them puny judges for about 60% of their very short tenure. So that means that they don't leave behind a proper legacy. They don't settle the law in an area. If we were to take a judge who is superb at tax law, right? That person should be given 6 to 7 years so that majority of tax law cases come to them and they settle the law before them. So what are the potential solutions? I will not go through all of them. There is a note that I've prepared which will come out as part of the stuff. But I've classified my changes into short-term, medium-term, and long-term changes. I'll highlight one each for the purposes of the discussion. For short-term, I think a couple of suggestions that I wanted have already been made. But I want to say that one thing that the High Courts can do immediately is prioritize the about 3.5 lakh plus cases which have been pending for more than 10 years, and give yourselves an internal deadline of saying, we will make sure that no case is pending for more than 10 years in the next 2 years. This requires setting up dedicated benches, clearing out the processes, getting lawyers to cooperate, getting the registry processes to cooperate. I think it's possible. A medium-term solution, maybe to raise the ratio of bar to subordinate judiciary judges to the High Court to be raised to at least 50-50 from the 70-30. The reason I also say this is because there is it gives the signal to the judges in the subordinate judiciary that if you're good enough, you will make it to the High Court for a substantial period of time. Your career won't stagnate in the subordinate judiciary. Second, these are judges who have dealt with criminal law day in and day out. A consistent complaint that a lot of lawyers and judges have made is that because the roster changes around, they are asked to handle criminal cases which in their career they have not. I can say this with confidence that many lawyers who get elevated to the High Court are writ practitioners or civil side practitioners. There aren't enough criminal side practitioners to make it to the High Court. But here we have a ready pool of judges who actually have in-depth knowledge of criminal law, who should be elevated to the High Court. Finally, one long-term change that I believe can be done in the High Courts, and especially in the context of criminal cases, is to use AI. It is possible. I think one of the things that sort of makes this delay a problem is the volume of the materials in a criminal law case. I know, for example, I know, for instance, and I actually saw this, that in dealing with the Bombay Blast case, the Supreme Court had to set up, actually, I think what was the first e-court in India, because the files were unmanageable. It required several trucks to bring the record. So they digitized it, parties collaborated, lawyers collaborated. The next logical step, in my view, is to use AI to be able to make the matter simpler. If you could scan all this, and if that software could be able to say instantly facts, evidence of A1 to evidence of all the witnesses, here are the major contentions of all the lawyers, here are the contentions against the various accused, I believe criminal appeals will move fantastically quickly. Finally, I want to end with one provocative point, and one which I hope will spark some discussion. Maybe we have been thinking about the Supreme Court wrong. The Supreme Court, in my view, performs 3 to 4 different functions, but the 3 most important are, it is the apex criminal court, it's the apex civil court, and it is the apex constitutional court. Maybe one body doesn't need to do all these 3 functions. All these 3 are very important functions. Maybe it might be necessary to engage in the conversation that setting up a constitution bench may not work, setting up separate divisions in the Supreme Court may not work. Maybe it is time to disaggregate this into 3 different entities, which will each develop their own jurisprudence, which will each develop their own procedures, and which will all be able to do justice to the functions that have been given to them under the Constitution. So with that, I will end my remarks and hopefully we'll elaborate on this as we discuss. Thank you.
Yeah, thank you, Alok. May I now request Ms. Kathy Patterson?
Yes, thank you. Very, very interesting listening to all of this. First, I'm very honored to be invited to participate this evening or Sunday morning in this program. And I also wanted to extend greetings to Justice Lokur from Ninth Circuit Judge Clifford Wallace, and also Northern District Judge Jeremy Fogel, with whom I think Justice Lokur has been worked over the years and continues to work. And they send their regards to you, and I talked to them a little bit about this started. What I wanted to do is to just in preparing for the program, I reviewed all the materials that I was sent. I actually did listen in on yesterday morning's program on the civil court reform, which is very helpful and I think covers some of the same challenges that we are talking about today. So what I wanted to do is really, I think, talk more on a more practical level in terms of what I bring to the table is more in terms of case management and how do we run the courts administratively and how do we make the cases go through the system to help the judges decide their cases. I've worked for the Ninth Circuit Court of Appeals for more than about 40 years, long time, and saw changes through that time. As I'm sure you know, the federal courts in the United States, there are 2 separate court systems. There are the state court systems that are totally separate, and then there's the federal court system, and the apex is the US Supreme Court. My experience is with the federal courts, the Ninth Circuit in particular, which is the largest federal appellate court in the United States. It has roughly 29 active judicial positions, and then an additional roughly 18 to 20 senior judges who work for the court. The judges, unlike India, are appointed for life tenure. So they are there a long time. They have a lot of institutional knowledge that they gain over the years, which I think my bias is I think that makes some sense. The judges sit in panels of 3 judges. There is an en banc function of 11 judges when the majority of the court decides it's such an important case that it requires a larger bench to decide it. But one of the things I wanted to talk about, sort of emphasizing the role of the judges and the role of the staff. And as I said, I think the role of the staff is to recognize that the judge's time is the most important time. And the idea is to get the cases ready for the judges. So when they get the case, they can decide it. They don't have to spend a lot of time on administrative matters or procedural and the like. And as such, you need a strong registry or clerk's office and support staff to make that all happen. The other point I'd make is that in terms of case management, once the case is filed with the court, it is in the court's control. The court then controls the case, not the lawyers, not the parties. The court sets the rules and sets the timelines and then tries to enforce those deadlines and make sure that the cases move through the system on a timely fashion. That's generally not all that well received by the bar at times, but I think it makes the court function better, and then it helps in the expedition decision in cases. The other point in terms of just explaining how the Ninth Circuit works and what applicability it might have is when a case is first filed with the Ninth Circuit, and our numbers are, the numbers that we heard in the beginning of this program are staggering in terms of the hundreds of thousands and millions. I mean, beyond the Ninth Circuit, we are about, right now, I think the court is getting about 10 to 12,000 cases a year, which is obviously very, very little compared to what India is dealing with. but we still have some of the same problems. And one of the things that we have done is when an appeal is first filed with the Ninth Circuit, we have a central core of staff attorneys who look at the case immediately. And their role is to figure out, does this court have jurisdiction? Is it actually ready, a final appealable order that is now appropriately before the Ninth Circuit? Many of those cases are not, so they are immediately dismissed by a panel of the court that is dealing with that, but they are worked up by the staff members so we don't have to waste a lot of time sitting on the shelves. And 3 years into the court's case, we realized the court never had jurisdiction. So that has been something that the court has done over the years, and I think it has tried to help. It's helped keep the cases moving. The other important point, I think, and I think is definitely, I understand works in India as well, is the role of mediation. And the Ninth Circuit has 10 mediators who work for the court directly. And they look at the civil cases as they are filed, and it's limited to civil cases. They have the parties fill out a brief questionnaire to see if if the case might be appropriate for mediation or settlement. Often, as I was mentioned in the program yesterday, is sometimes settles. It's just the parties have different, issues before them, and they just want an opportunity to be heard in some fashion or another. May not really care about what the legal issues that's in dispute. The mediators resolve about 1,000 cases a year through the mediation practice. Mediating the judges, which again helps keep practice that we have. So we're trying to get rid of the cases early on, either through lack of jurisdiction or settlement, or the parties ultimately decide they don't want to prosecute the appeal. But assuming the cases are going to move forward, the parties have deadlines in which they have to file their briefs. They have to file both written briefs, each party, and there's a fairly strict deadline as to when those have to be filed and how many pages or how many words are in each of them. That there's a limit to what judges can read and comprehend. So those cases then are filed, and we have another group in the staff attorney's office who review those cases, and their role is to figure out what are the issues that are being raised in the appeal. And to the extent possible, we try to group cases by issues. So if a certain statute is being challenged, or there's, if it's a prisoner civil rights case involving certain issues, those cases try to group them together and have the cases assigned to a particular panel. And in some cases, what we will do is we'll send up a couple of lead cases to a panel and hold the rest of them, with the goal that if those cases, if the panel decides the legal issue at hand, then the other cases can follow. And those staff attorneys as well, in addition to determining what the legal issues, and this is all fed into a case management computer so it can be tracked and followed, they weight the case in terms of the difficulty and the expectation of how much of a judge's time it might take. And the weighting system that we have used for many a year is basically a 1, 3, 5, 7, and 10 weight. 1 being sort of the simple slam dunk, case that won't take very much of a judge's time, and then obviously take more of the time. With the 10, would take a lot of the judge's time to resolve. The one-way cases, as we refer to them, are sort of shuffled off. They do not receive the full panoply of the appellate process. They are resolved on the briefs by a standing panel of judges who are assigned for a given month to handle all of those simple cases that come in the door. And then the other cases go to the more traditional route of the oral argument panel, and they are grouped together. Before we had the pandemic, the judges would sit all over the circuit, physically go to the different cities within the Ninth Circuit. Now everything is virtual, as I'm sure it is in India as well. So that the cases would be grouped together. Again, it's trying to just keep track of the cases and move them through the system. And another point I would just like to make is the role of the staff is such that you do need a professional staff, and you need to have, clear training to keep the staff up to speed as to what's done and to clear what the expectations are. We also have employed the use of a lot of paralegals in the Ninth Circuit because they're cheaper, quite honestly, than attorneys, and they can perform certain functions, administrative functions that may not require the full legal degree and experience. So those are my main points. I do think the weighting system might have some applicability in the case management, tracking of issues in the courts. May help you just have a better handle on what cases are in your system and what can be served up in the different panels before your courts. The only other point I might make is if a panel, if a three-judge decision is reached, and we have two methods of decision making in the circuit. One is what we refer to as sort of an unpublished decision, which is basically, it's not precedential. It's sort of a very straightforward, 3 to 5 page decision. It's generally pretty easy for the judges to produce. The more full opinions of the court, which are the presidential ones, take a lot longer. And those are the cases that are much more difficult and require more time and consideration. And those are generally handled in chambers. Each of the judges have 4 law clerks with whom work closely with the judges. But if those cases, if a 3-judge panel decision, a party may petition for rehearing en banc, and that's when an 11-judge panel may hear the case. That happens very infrequently, maybe 10 to 15 times a year. And then ultimately the cases could go to the US Supreme Court, although that too is very, very rare. The Supreme Court of the United States is only hearing about 80 cases nationwide total. So the Ninth Circuit, as you were saying, and the high courts are generally the courts of last resort. I hope that is helpful. I'm happy to respond to questions if there are any as we proceed in our discussions. But again, I thank you very much for the opportunity to participate.
Thank you, Kathy. Mr. You have made some very interesting observations. I just wanted to be a little clear on your thoughts when you say that because of the tribunals that have come up in different parts of the country on issues like the Central Administrative Tribunal, for example, and so many other tribunals which have converted the Supreme Court into the first appellate court, right? What do you think is the solution? Can we get rid of those tribunals, or should there be something in between? What according to you would be the solutions to that?
One solution possibly, this is just off the cuff reaction, could be that the high courts could be the first level of appeal, instead of the first appeal being to the Supreme Court itself. This is not only with regard to administrative tribunals, but I suppose large number of legislations where the appeal is taken to the Supreme Court, it's also there. So maybe you could have the high courts as the first appellate court, restricting the appeals to the Supreme Court to points of law. To some extent that the work of the Supreme Court gets reduced.
Yes.
In the already large work that they have.
Okay, but then that will require more judges to be appointed in the high courts. That's one. And of course, you have mentioned about appointing ad hoc judges.
Yes.
Let me tell you, when I was in the Delhi High Court, we did think about appointing some ad hoc judges because there were a large number of vacancies.
Yeah.
But there was a tremendous resistance from the bar. They said, "Are you trying to tell us that we don't have good enough lawyers, or lawyers who are good enough to become judges? A retired person?" That's
I know. Yeah, this is what you called a very vicious circle.
Yeah, and you did mention
till the judges are appointed, till new judges are appointed, at least for some time, you could have this arrangement, possibly.
Yeah, but then the argument with the bar was, you are the guys who are supposed to appoint.
I know. So you fasten that.
What
Yeah.
do you mean?
I understand. Yeah.
And you see, you did mention about constitution benches.
Yeah.
Maybe one, maybe two on a
Yeah.
permanent basis in the Supreme Court. But my experience has been that the Chief Justice of India is a little wary of
little?
setting up. Is a little wary, or maybe overcautious about setting up a constitution bench, because the Chief Justice believes that, well, if I'm going to put 5 judges to hear a constitutional matter, the number of cases are going to pile up. Okay, so from 48,000, it went up to 50, 52,000, 55,000. Now it's crossed 60,000.
Yes. 60
Okay.
plus. Yes.
Yeah, 60 plus. So that is one of the, fears, if I may,
Inhibitions.
inhibitions that the Chief Justice of India has about setting up a constitution bench. How would you react to this?
No, I would think that what you mentioned at the very beginning, you filter the, you filter at this 136 jurisdiction. I think the pendency is also because of the large number of leave being granted and petitions converting into appeals and pending. If some restriction is there at that stage, and the other mechanism being used, which you were referring to, that's the certificate of fitness being granted by the high courts, which was very common in the 50s and the 60s. Possibly, I think one reason that people don't go through that is because the limitation, you have a larger limitation if you go directly to the Supreme Court under 136, 90 days. I mean, I don't know, maybe that is one reason, but this is also a mechanism which should be used, where the certificate is granted by the High Court saying this is a matter which the Supreme Court needs to look into. Otherwise, of course, 136 cannot be legislatively restricted, but I think the judges themselves, by an exercise of some self-restraint, would have to draw the line. And that, I think, would have an effect where you can devote more time to the constitutional work. And I think you will agree with me. I'm an outsider with your experience in the court. Even constitution benches, sometimes we know the judgments come on the last day when X judge or Y judge or the Chief Justice is retiring, and how much time your lordships are really able to spend on thinking, ruminating, discussing serious issues. I think you would know better. I think that is also an area which calls for serious considerations. If something could be done on that, instead of rushing through. Of course, we get a decision, but the decision, the process of arriving at the decision could, I believe, be better. And the only thing I can think of is 136 being, to some extent, restricted by self-restraint.
You're right. It can only be self-restraint.
Yeah.
You can't curtail it by.
No. That would be blasphemy to curtail it by.
Alok, I have a few thoughts. You see, you're right in saying magistrates are also constitutional courts in that sense. I know that in the National Academy, an attempt was made, and it is still being made, to introduce something called a constitutional vision or an understanding of the Constitution, at the level of the district judiciary. So that is certainly very, very important. I think that's a very important point that you have made, that you can't just say that, well, listen, you guys have nothing to do with the Constitution. So that's very important. But, I am not very clear about, you had suggested, maybe 4 or 5 high courts in each, benches of high courts in each state. See, the problem really is one of access to the High Court. Now, if access is easy to the High Court, even if it is situated in the capital city, right? people can come. In the United States, for example, you have the American Supreme Court in one corner of
The country.
the country, but you have a lot of people coming from, from Alaska, from Hawaii. So it's really access, which is important. Multiplying the number of courts, may or may not have that kind of a value, in the sense that if you have, 5 high courts in each, say, 20 of the larger states or middle size and larger states, you will have 100 benches, or 80 benches. And if they are going to start deciding, constitutional issues, right, or concentrate on constitutional issues and not merely dispute resolution, as Mr. Pai said in his opening statement, then you're going to have, so many conflicting interpretations of provisions of the Constitution, and in a state, so many, different interpretations of the same statute, that probably going to be far more confusion, than clarity. Yeah. How do you react to this point of view?
So, in my experience, and this is something that was also came out from our data, what happens is, supposing, and I'll give you the example of Karnataka, this can be extended to most large states. Supposing, and Mangalore is of course on the coast, it is well developed. Somebody wants to file a writ petition against the Mangalore civic authorities. They have to come to Bangalore. Civic authorities also have to come to Bangalore. Now that means that every time that a hearing has to be scheduled, you have to figure out what is the time, put time, unlike say for someone in Bangalore itself to come and address. Now, I don't dispute that, yes, there may be some contrary rulings, but I also believe it will not, like for instance, the Supreme Court, if you look at it that way, and this is a common joke made of the Supreme Court, that we don't have one Supreme Court, we have about 14 Supreme Courts. So in that sense, if I have to be a little cheeky, I can say 5 is okay, manageable problem. but in all seriousness, I do think because the common pool of judges is the same, what I'm suggesting is circuit benches where the same, like in Karnataka, as we have 2 circuit benches, the same judges go and serve in different parts of the state. And the average high court judge serves between 7 to 15 years. Very rarely you get short-term appointments. That means that that judge is steeped in the culture and the precedents of that court. So, and I have seen this, that a lot of times, and high court judges say, oh yeah, it's covered by that, why are you raising this point? Move on. Which gives that natural stability to the way the law, again, looking purely at state level issues, like as we sort of suggested that high court should be like the Supreme Court for that state. If you have high court judges who serve 10 to 15 years, who circulate among these benches, they'll know. There will be very rare issues. I accept there will be very rare issues. But I think in exceptional situations, we can give the Chief Justice enough discretion to constitute a full bench or whatever it is, to bring all these cases to one bench and sort of have them heard. Which, again, in exceptional cases, totally worth it, should be done. I'm not saying don't do that. But I believe that it will not be as much of a problem. It is something that is easily addressable. And this is an experiment worth trying for the simple reason that it both serves the purpose of access. Because one of the things that we find is that even in terms of less well-developed parts of the state, there is active judicial exclusion going on. Daksh did a fascinating study on this, which talked about the judicial exclusion. They're solving 2 things. One is we are saying that we take the courts to the people. And second, the court's own function improves when the litigants aren't troubled by having to travel from one corner of the state to the other for issues. And I think the problem is most significant in a state like Uttar Pradesh, where people in Noida have to end up going to Allahabad, or even for that matter in Karnataka, where those from one end of the state, Bangalore isn't like the southern tip of Karnataka. And Tamil Nadu has addressed this, but I believe that this is something that will actually make for better judicial administration if people feel that, I can get this resolved because it's not as far away from me as I imagined it.
Yeah, well, it's an idea that certainly deserves consideration, but let me tell you my experience in Guwahati.
Sure.
When I was there. At that time, the Guwahati High Court had been listed for
7,
right?
Yes. Yeah.
Their own High Court. But people from the other states preferred to come to Guwahati.
Okay.
As far as Mizoram, coming from Mizoram to Guwahati, not that simple. but they preferred to come to Guwahati rather than go to the bench in Mizoram. So also in Arunachal, you know.
Hmm.
I don't know what is the reason for that? Either perhaps, the lawyers in Guwahati or in Assam were perhaps better equipped or something, or maybe the judges were better equipped in the sense of, more competent. I don't know. But then we
Sure.
had judges going to the, different high courts,
Yeah.
to the different benches.
Benches.
For example, I went to all the states,
Mhm.
the senior most judge also went to all the states,
Mhm.
right? So really, I think, the experience in Karnataka may of course have been different, but I think we need to give it some thought, on a
Sure.
broader perspective to see
Sure.
what really is in the mind of the litigants, whether they prefer, coming to
Yeah.
Bangalore rather
Mhm.
than going to Gurgaon or some other place, or whether they prefer to
Yeah.
go to Lucknow or Allahabad. But it's a
Yeah.
good specialization is something you had mentioned. Mr. Sudesh Pai had said that he is not much. One of the problems of specialization is an ingrained
Yes,
idea.
yes.
I am a person who thinks that the government is always right in tax matters, and these guys must be fixed who are evading taxes. So you put me on the tax bench for 3 years, I'm going to upset the entire tax law in favor of the government and against,
The
the
citizen.
citizens. We've had judges in the Supreme Court who were said to be pro-tenant,
Yes.
pro-labor. So if you were a landlord, you had zero chance of succeeding. That's one of the dangers of specialization.
Yeah, it's not always a good idea. It's just an idea which we must think of, but I'm never sure it is good.
Yeah. In fact, this idea has led to those specialized tribunals. Like you have the okay, or you have a tax tribunal. Tax tribunal, of course, is
Yeah. The company law tribunal. Yeah.
So that has probably led to that. But I'm
But
not sure
how
whether
successful or effective are they? I don't think our experience is good at all.
exactly that's the point.
Yes.
So
I think
really,
we are far worse now with these tribunals than anything else.
Yeah, so I think that idea requires a lot of thought.
Yes, it's just an idea to think about. No?
Yeah,
And I think now I saw that there's some bill in Parliament to revert to the High Courts certain powers from some of these tribunals.
That's right.
Five tribunals have been abolished.
Yeah.
Abolished. Yes.
But many of them were, not very consequential, except for the, intellectual property.
Appellate court. Yeah.
So those cases will come to the High Court. But some of them were not of much consequence. Kathy, Sudesh Pai, sorry, not Sudesh Pai, but Sumedha had mentioned in her opening, introduction about law clerks, the need for having law clerks. You did mention about, attorneys who filter the cases before they are taken up by the judges. How does that system actually work? And do you have law clerks in the, Ninth Circuit?
Yes, there's a central staff office, it's sort of part of the registry or clerk's office, and in the states consists of both clerical staff, but also probably about 80 to 90 attorneys who work centrally for the court. They're not assigned to a particular judge. They're the group of attorneys who work up the cases so that they're ready for the judges, and then the judges then and their law clerks take over when the case is at issue and ready to be decided. So they're ones who do the classification. They also deal with the motions practice before the circuit, before a case is actually submitted to a panel of judges for decision. Generally, the court has limited the tenure of those attorneys generally to 5 or 7 years. So in order to avoid sort of a hidden judiciary, so that they don't have too much power. so that, but they have supervising attorneys who watch their work. They report, indirectly to the chief judge of the circuit. But the court couldn't function without them, quite frankly. And they have some of the attorneys will specialize in certain areas of law. We have a group that really, deals with, we have a lot of immigration cases in the Ninth Circuit. So there's a special group that deals with immigration. There's others deal with sentencing law, but they do, they're a valuable resource for the court in terms of keeping it running.
Do you have issues of, specialization kind of thing, like, Sudesh had mentioned or Alok had mentioned, judges who specialize in certain things, certain areas, certain disciplines of law?
Yeah, the judges do not. They debated that same topic. It sounded rather similar. I think the judges feel very strongly that they are generalists and they don't want to have, be labeled a tax judge or an immigration judge. So, but the thing that we do that attempts to get at that issue is keeping track of the issues, so that, if we get a lot of cases raising the same issues, the judges are made aware of that. So the idea is you don't want to have different panels of judges, who have the same issue before them, but at different times issuing, different decisions. So the judges are notified that, this panel looks like it has the same issue. You all might want to consult. And how the court's policy is, the panel that gets the issue first decides it. So if it's, an issue of first impression in a new law that Congress has passed, the panel will be notified you have this issue, and all these other cases are waiting decisions. So it's not specialization, but it's issue identification and trying to keep track so you have a consistent body of law.
Okay, I take it that this is a part of the process of case management. Would it be correct to say that this is a part?
Yes.
Yeah, okay.
Yes, very much so. It's a part of the case management system in terms of trying to keep the cases together.
Kathy had mentioned about Judge Fogel. He was a federal judge, then he became the director of the Federal Judicial Academy in Washington. He had come to Delhi and he gave a lecture in the Delhi Judicial Academy on case management, right? And at the end of the lecture, one of the judges asked him, how many cases do you have on your docket? So he said, I have 300 cases. So the judges said, well, with 300 cases, obviously you can do case management. We have 1,500 cases on our docket. I asked Judge Fogel, he said during his lecture that he'd been doing case management for 3 years. So I asked him, I said that when you started case management 3 years ago, how many cases did you have on your docket at that time? He said, at that time, I had 3,000 cases on my docket.
Wow.
So in 3 years, he brought it down from 3,000 to 300.
Yeah.
And other judges were complaining about 1,500 being too much. So I think what he is saying about case management, is something which is very, very important. And unfortunately, we're not paying that much of it. And I think this idea of, a section of lawyers or attorneys, 40, 50 of them to assist the court is a great idea. That work, by the way, Kathy, is being done by, the registry in our courts. Now, some of the people in the registry have a law degree, but many of them don't.
Right.
So that kind of, expertise or understanding of the law does not come into this process, but I think getting professionals is very, very important. Yeah. So I think that's pretty good. We've had a wonderful discussion. Alok, your idea of having, several Supreme Courts, specialized Supreme Courts, they have that system in Germany.
Yeah.
So they have a federal Supreme Court of, tax, fiscal matters.
Yeah.
But again, that thought about specialization, which Sudesh and Kathy had mentioned, that kind of, well, you need thought about it.
Mhm.
Artificial intelligence, you need to think about it. How do you
Yeah.
make algorithms? Because if you inject bias into the algorithms without
Yes.
writing trouble.
It is. You're right. And let me just elaborate on that artificial, because I didn't get too much time to talk about it.
Yeah.
It is only in the sense of helping the judge. The decision at the end of the day is the judge, because what we find with a lot of criminal appeals is that the voluminous records mean that the lawyers take a lot of time to argue the cases, the judges take a lot of time to argue the cases. If we were to start with a system where, as soon as the case is about to begin, the judge has an immediate set of something on the screen which says this is the findings against all the accused in this case. These are the evidence of the various witnesses in the case. These are all the documents and how they correlate to the offenses of each. And like this is what has been given as a reasons. Now, there is one way to eliminate bias is to make the training data as wide as possible and not introduce any bias in the training data itself. If we were to take every single criminal judgment passed by courts across this country, scan them, and let neural networks run through them so that they can pull out all the relevant aspects of it, I think we'll have made a good start. And I don't mean that the AI will judge. The AI will absolutely not judge. The AI purpose is only to be an assistant to the judge, like what perhaps would have been had to do manually to say page number this, para number that, correlated to what the trial judge has said and understood in this process. Because one thing that can happen immediately is it makes identifying errors almost trivial. Supposing a witness has said that I did not see X at this point, and the trial judge has accidentally said, witness said I saw X at this point, it makes identifying the error or almost a trivial exercise. So I'm giving just one basic example, but I do feel that what AI will do is to make the life of both the lawyers and the judges. The lawyer doesn't have to, I will take my lordship through every single paragraph of what the trial court has said in this point. Like the judge can say, look, we see what the case is now. These are the three main points you may have a ground for appeal in. Argue these 3 points, take us to the relevant paragraphs. I think that is really where I see technology helping in the quick disposal of criminal cases. Because, I mean, and to be quite honest, we're in the 21st century. We can't use 19th century ways of resolving disputes, even criminal cases. And because these cases are a huge number, they sit in the court and they take a lot of time. Judges' time and energy could be better used for their core constitutional functions.
One topic that we did not discuss, of course, it didn't arise, is that of judicial education and training. Kathy had mentioned. I think that is something which is very, very important. Judicial education, continuing judicial education for judges, and training for the staff. Which is what Kathy was mentioning. But I suppose we'll have to leave it for another day.
But that's what perhaps the judicial academies are trying to do to some extent.
Yeah. But then, there has to be an audit. How far have they succeeded?
Succeeded, yes.
But anyway, we can leave that for another day.
Occasion.
So we have a couple of questions.
Yeah, so that's very important point is that we finished on time.
Yes.
So the first question is directed to you. So basically, in the background of this heavy caseload on high courts being a very long-standing problem, for more than 70 years we've been debating it. So what is the reason that we're still not able to effectively tackle it? Has our approach been wrong, or is it a lack of will, or what is the problem?
Well, if you want me to be a little blunt, the answer is we've not made an effort. Right? It can be tackled. I am absolutely confident about it. It can be tackled. But we have to make that effort. And at one point of time, I had mentioned about a mission mode project kind of thing. It can be done, but make that effort and it will succeed. I have no doubt in my mind.
So as a follow-up to that, so There is an argument that the problem with the constitutional courts is not one of resources. The approach cannot be just increasing the number of judges. It's more a structural issue. So what would be your comment on this?
Yeah, you see, case management is something which Kathy had mentioned. Very, very important, right? Streamlining the processes. You can't have, Alok was saying 19th century, dispute resolution techniques, but you have 19th century rules, In one state, they have not amended the rules so that, the process server can actually go on horseback to serve process. What are we doing? So I think there has to be that, solid effort made, and we can achieve wondrous results.
Okay, thank you, sir. The next question is directed to Alok Prasanna, sir. So you mentioned that criminal appeals take a long time to get disposed of in the high courts. What is the reason for that, and what should we do about it?
2 or 3 reasons which come through, and this is something that we at Vidya are also researching. So you'll see more fine-tuned results when we discuss this. The first problem is that it is actually, we as lawyers may say, oh, specializations is bad, but it is a very highly specialized skill to be able to argue a criminal. I'm not talking about person caught for theft and they filed a criminal appeal. I'm talking about the kinds of criminal appeals which end up in high court, which is usually on the question of conviction or acquittal of a fairly high-profile case where lots of witnesses, lots of documents are involved in the question. And the ability to read through that many documents, to be able to coalesce them into a coherent story, break it down as to why it's right, why it's wrong, it's not something that, say, even people with 4 or 5 or 10 years of experience can do just like that. You need to have a long and deep experience training with the right criminal lawyers to do it. The second thing is that transmission of records from the trial, because criminal appeals involve records, like these really bulky records. Transmission of that takes a long time. Sometimes they're sent incorrectly. And again, it's what I go back to. We're still manually sending records. When all of this can be so easily digitized, it can be, one link can be shared and it's done. So we don't have those processes in place. The third thing is that because of the size of the records and so on, if as a judge, you're not very familiar with hearing deep, in-depth criminal appeals. I know a lot of lawyers who have made it to the high, and Mr. Ram Jethalani has also mentioned this in his speeches, and lots of high court judges have said, if you're not a lawyer who's had a practice in criminal law, like you will lose touch with the basic concepts and what you should be looking for. It's not like you just find one point, answer that point, and you're done with that case. You have to know how to read the evidence. You have to be able to pour closely through all the documents provided. It takes time. And that is one aspect of the nature of criminal appeal. So if you're somebody who's used to doing this, right? If you're used to generally handling large volumes of papers and evidence and so on, you'll do it much more quickly. But these are the 3 broad reasons why it actually takes a lot of time to dispose of criminal appeals at the High Court. I mean, the Allahabad High Court, everybody makes fun of because there are criminal appeals pending from the 80s and 90s, and you would have seen those numbers from the National Judicial Data Grid. But I'm sure every High Court grapples with this issue, and Allahabad, dealing with the largest state with possibly the fewest judges for such a large state, has an especially bad problem in this respect.
Thank you, sir. The next question is directed to Ms. Catterson. Ma'am, how do the circuit courts delimit their jurisdiction? So we talked about how there should be a self-restraint on the part of the judges in the Supreme Court to not let every case reach their bench. So are there any rules or practices or conventions in place by which the judges on the bench decide which cases they get to adjudicate upon?
The appeals to the Circuit Court, to the Ninth Circuit, are appeals by right. So it is not a certiorari process, or where, as it is in the United States Supreme Court, where the court will select which cases they want to hear. It is an appeal by right. However, There are lots of statutory laws, federal laws that set forth the jurisdiction as to what courts can review. They have to be final appealable orders of cases decided by the federal district courts within the circuit. So there's a whole series of statutes and case law that helps define what is a final appealable order that can be heard by the circuit. So it's a combination of both. And that's what I was mentioning earlier. The role of the central staff attorneys is to look at that question as soon as the case is filed, the appeal is filed, to see if the court does indeed have jurisdiction. Because what you don't want is you don't want piecemeal appeals where a case is still below at the trial court, at the district court, and then half the case is up here and the other case, and it goes ping pong. So I hope that is responsive to the question.
Thank you, ma'am. So we next have a question for Sudhish Pai, sir. Sir, the recommendations about setting up permanent constitutional benches have been made at various points in time by law commissions, but have been repeatedly being rejected by the Supreme Court. So what is the reason for that, and how can we persuade or bring this about?
I think that question was answered by Justice Madan Lokur when he said the Chief Justices were wary about constituting regular constitution benches. I believe the Chief Justices should get over that inhibition, if I may say so, with great respect. And one way of doing it is, as I said, you restrict your SLP jurisdiction by a wise exercise of self-restraint. How to do it, of course, no one can prescribe, no law can lay down. I can't tell, you can't tell. It's something that judge, it has to come, and it will come. When you sit there, as Justice Frankfurter rightly said, that the ropes of the judge changes the man within. I believe it is so. So you will get it as you sit there. And well, you can't have any thumb rules for that. And once you reduce those kind of cases, I'm sure you will be able to devote more time. And let me go one step further. It's not a question of you will be able to do. I believe you have to, because that is your primary job. As I said at the very beginning, the primary job of the Supreme Court is to be a constitutional court, not an SLP court deciding, sitting as two judges and telling us how much rent you should pay, 25 rupees or 40 rupees. I think it's not worth the life of a Supreme Court judge to do that with utmost respect. Most of the time, their life and work is wasted, if I may say so with great respect. They need to devote time to better things, loftier things, more sublime things.
Can I very quickly add one point to what Sudhish Pai has said? Hello?
Yes,
sir. No, but I think very recently we have seen this very good trend in the Supreme Court of the judges restricting counsel's time. I think what used to happen with constitution benches in the past was that far too many counsels would line up to argue pretty much the same thing, because they were briefed in the matter, and far too much time was given to them. I think of late we have seen the Supreme Court sort of setting and enforcing time limits, and I do believe that should be a matter of practice now. The Supreme Court should have like one preliminary hearing where they say, okay, 2 from the petitioners, 2 from the respondents, 2, no more. And maybe if there is one intervener, 1 from the intervener, or we give all interveners about like half a day to make your arguments, you divide the time among yourselves. And make those timelines, hold to them strictly. And the main concern with Justice Lokur pointed out, which was that how much time will be taken up of the judges in these matters can be limited. If we can say, we can have a hearing over 3 working days in the Supreme Court in the middle, by through sensible time management and being strict about it, I think Chief Justices will not worry so much about how much time to allocate for constitutional benches.
And I also, if I may add, at the end of the hearing, I think the judges must have a meaningful conference and discussion before they really proceed to judgment.
Yeah,
they do have a conference.
But I wouldn't engage with you, but how meaningful is it? I think you would know better.
It is meaningful. We do have conferences. It's not I go to my chamber and say this is what I'm going to do. We do.
Okay, good.
Sir, on that point of restructuring the Supreme Court, the recommendations have been very wide-ranging, from establishing permanent benches to what Alok Prasanna sir talked about, disaggregating the functions itself into 3 separate courts. And there's also been a recommendation for establishing an intermediate court of appeals. So what is your comment on that, on each of these recommendations, and where do you see this going? This is
Sorry,
for the entire panel.
Sure.
Sorry, is that addressed to me?
So this is for the entire panel.
Okay. Yeah, well, as far as I'm concerned, before looking for alternatives, we need to strengthen our existing systems. We need to utilize our existing resources to their complete full capacity. We are not doing that, So if we don't, tighten our belt, strengthen our systems, looking at alternatives is an easy solution. But let's first, try and do something to our existing system. I will give you, 2 instances. One is, the record room in the Supreme Court had not been cleaned up for I don't know how many years, right? I spoke to the Chief Justice, and we called a lot of retired officials from the registry to come and work. We paid them extra for it, and they sat for a couple of months, right? And they cleaned up the entire record room, got rid of a lot of junk. The result of that was a new bar room. Lawyers had been agitating for a bar room for years. And once that thing got cleaned up, you had a bar room, first-class bar room for the lawyers. Okay, that's an idea of spring cleaning. You mentioned about law commission, reports. How come states don't have law commissions? There are just maybe 2 or 3 states that have law commissions. So if you want to strengthen the high courts, you want to strengthen the district judiciary, set up law commissions. They understand what's happening over there. And improve the system from within. If you can't improve the system from within, then look for alternatives. But don't look for alternatives and then say, well, listen, so far as the existing system is concerned, I'm not going to do anything about it. It can't work like that. You're putting the cart before the horse. You can't do that. So I think my straight answer to your question is, let's get down to business. And let's improve whatever we have got, utilize our resources to the best of our ability, and then think about other things. Okay, that's my view.
I don't think I can agree more with what Justice Lokur has said. We need to tap all our resources and mobilize it in the correct method. I don't believe we have still reached a point of no return, that we must look for something outside. Within the existing framework, a lot of things could be achieved. As Justice Lokur said in the different context, we have not tried our best. I think we must apply ourselves with dedication and one single point attention. And I think to a large extent, things could be improved. Then, of course, we can see if other things are necessary, is my belief. Thank you.
So let me strike a slightly discordant and maybe a dissenting note from what has been said so far. I do believe that large-scale institutional reform in our judiciary is needed. And it's something about the structure as well. I think when these institutions were set up in a specific context by the framers of the Constitution, keeping in mind certain needs, we have 70 years of data, if you want to call it, on how they have functioned, what they've been able to do, what they haven't been able to do. And when I say we have to bring about institutional reforms, I don't mean tomorrow. I don't even mean maybe in the next 5 years or 10 years. What I want to do is that while we are strengthening the existing institutions, making them more efficient, we have to accept that they will also hit a limit of their efficiency. There is only so much that they're going to be able to do, even if we make them function as best as they possibly can. We use every new metric, every new technique in management, case management, and in terms of using technology and so on. And what I do believe is that if we start the conversation now, there's a very fascinating book which talks about the origin of the idea for a Supreme Court of India, and it wasn't as if one day it occurred to someone in the Constituent Assembly which was Supreme Court. The idea was debated and discussed starting from the 1920s onwards, and people had an opportunity to give their views. Some people changed their minds, some people stuck to their original views. So when I sort of propose institutional reform, I say it in the sense that it is something we may have to do in 20 years from now. But if we start the conversation today, we'll be in a ready position to make those reforms when needed, rather than finding, oh, we have hit the limit of efficiency in all of these things, now what? So that is, I do believe eventually structural reform is needed, will be necessary. But if we start the conversation today, we'll be in a good position to have a structural reform. While at the same time, we can do what Mr. Pai and also Justice Boko suggested, ensure that the existing institutions work to their best and fullest capacity. But the task of, constitutional running our constitution, right, working a democratic constitution is never about sticking to one thing forever and hoping that the world changes around us. We have to be able to accept that the changing world should mean that our institutions should change.
Yeah, Kathy, any thoughts on this?
I'm not sure I am in a position to tell your country what to do, but I think I would say I find I concur more with Justice Lokor and Mr. Pai in terms of fix what you have before you add a whole nother structure.
Yeah.
I may step in, Mr. Chairman.
Yeah, sure, of course.
Now, one issue that's coming up repeatedly is the quality of judges. Our legal education is very deficient. You mentioned the difficulties of training and so on and so forth. Mr. Pai talked about integrity, competence, and character. At the end of the day, when you have a Justice Madan Lokur or somebody of that caliber, the way things happen is one way. But judges in the same capacity but different character or ability, what's happening we all know. So how do we really ensure that the best minds are inducted, the quality is improved? Is Indian Judicial Service one possible approach? There are many approaches required. There's no single approach, but I think we have to focus on that.
Yeah, frankly, I don't know the details of the Indian Judicial Service. It has been talked about. Even today's newspapers mention about a statement given by the Honorable Law Minister. But the details are not out. So it's difficult to say it's a good idea or it's not a good idea, or what can be done or what cannot be done. So until that happens, it's very difficult to even comment upon it. But, there are two things so far as, appointments of judges are concerned. One is the salary. Okay. There are many lawyers who are, making in a day what a judge makes in a month. Okay. So some of the good lawyers don't want to become judges. I'm not saying that all good lawyers should become judges, because then there will be no good lawyers left. That's the other danger. So it has to be attractive. Second is the prestige that is attached to the office. Justice Scalia of the American Supreme Court did make a mention about, he said that when the number of federal judges in the United States increased from something like 60 or something to 300, there was a gradual decline in the prestige. So we can't have 2,000 judges, 5,000 High Court judges, 50 Supreme Court judges, right? So I think that has to be restored, and in that everybody has to work together. Now, when I talk about prestige, you can't say that, well, this judge, I'm going to transfer him overnight. We've had that experience fairly recently. Okay. We're not going to appoint this judge as Chief Justice of that High Court, because I don't think he should be appointed as Chief Justice of that High Court. He should go to some other High Court. Where is the prestige left? All this has to work together, and only when you're able to put this, in the basket, that persons who are competent, like you say, or persons who have character, persons who have integrity, They will come forth. Why is it that we don't criticize judges of the 1950s, 60s, and to a large extent even of the 70s? Why? They had good salaries. It was prestigious. You didn't have 2 dozen, 3 dozen judges. Well, all this makes a difference, and all this, and that's why I'm very glad that you've taken up some of these issues. We need to have it, not a day long, but maybe a week long discussion on many of these issues if we have to move forward.
Mr. Pai, any comments on this?
I think ultimately judges come from the same society. They don't drop from another planet. And I think your efforts in strengthening Indian democracy, the citizenry, after all, as they say, no office in a republic is as important as that of being a citizen. So if citizens are good, then I believe lawyers would be good and judges would be good, because judges come from the bar. And what is necessary, therefore, is to see that there is a general rise in standards in society as a whole. And that would, of course, this is a very maybe long off dream, but something for which we must have sustained efforts. I do believe that the standards in the judiciary are not very much to be talked of today, but we have to do, as just as Lokur pointed out, why is it that we didn't speak of anything ill of judges in the 50s and the 60s? I think their salaries were lower, but of course, maybe the money value was also different. 3,500 then was not such a poor sum. But that apart, I think a certain level was expected and maintained. Somehow we have to ensure that is restored, restoring the confidence in all that we do and in the people we have. Thank you.
Mr. Prasanna?
So I see this in a slightly different way, because the funnel of people who enter the profession and who end up becoming judges is very steep. Not too many people survive in the profession beyond 3 to 5 years, simply because we don't have an organized structure which allows someone to learn and earn a living in the first 3 to 5 years. A lot of talented people will say, this is nice, but I want a steady paycheck. I don't want to be running from court to court fighting over fees. If I don't have connections in the network, who will send me cases? I think it's a long-term project. It's not something that we can do overnight by changing criteria. We can improve criteria. We'll get a few more good judges. But if we want to have a structural solutions where we can be sure that every person appointed to the High Court and the Supreme Court is of the highest quality, what we will need is to ensure that the pool of people that we're selecting from are of the highest quality. Likewise, for the subordinate judiciary, I hate to use the term subordinate judiciary, but unfortunately it's in our constitution. The district courts also, how much effort do high courts take in ensuring that each judge is performing to the best of his or her capacity? Are the court judges simply writing their ACRs and saying, outstanding, outstanding, outstanding? Are you looking at them with suspicion because they've passed liberal bail orders? Are you helping them update their skills? Are you noticing who are the good ones and promoting them ahead of chance? These are all the structural ways in which we improve the quality of the judiciary overall, because things travel downwards up. It is very hard, in my view, to simply ensure quality at the top and then expect it to come down. It will happen upwards, upwards from the bottom. So I do believe these two things which I've sort of suggested ensure that talented young people stay in the profession for long and eventually go on to become talented seniors. And likewise, those who enter the judiciary, they feel that they are constantly being given chances to upgrade their skills, and that assessment is done towards a view of ensuring quality and not just administrative experience.
Ms. Catterson, in your country, while the competence of the judiciary is not really questioned, the way the judiciary conducted itself in the 60-odd cases that Donald Trump filed is a remarkable lesson, irrespective of who appointed the judges. But on grand matters of policy and constitutionality, it appears that the judgments of many Superior Court judges is pretty predictable. The Supreme Court oftentimes 5-4 or 6-3, depending on who appointed them or what their ideological predilections are. We're pretty certain to know what's likely to happen, notwithstanding the Chief Justice's efforts to balance the scales. Do you see any problem in that in the long term?
I think the system works fairly well for the most part. I do think, as you know, federal judges in the United States are appointed for life. So that gives them sort of the independence, not to be worried about their next job or their and the like. So it's balancing. I think for the most part, I think the federal judge, it's a smaller bench, obviously, than the state court bench around the United States. So, it is very competitive. I would just comment, though, in terms of the judges, actually, the federal judges in the last 3 or 4 years actually sued to get a pay raise. And they kept worrying that everybody would recuse themselves, but ultimately they got their pay raise. And I think it was a similar concern that many good lawyers made more in a week than a federal judge made in a year. So, I mean, it's an issue. But the prestige, I think, is still, for the federal judiciary, is still remarkably high.
Samantha, if you have no more questions, we'll ask the chair to make concluding remarks, or do you have a question or two?
No, sir. We can go ahead with the concluding.
The floor is yours, and after that, Sumedha or somebody will propose a formal vote of thanks. Mr. Justice Lokur.
Yeah, well, thank you very much. I must thank all the panelists for being so forthright in their views, right? But there is this great churning that is going on. So many issues have been thrown up by Mr. Pai, by Alok, by Kathy. We need to think about all these things. And like Alok said, it's not something that you can change in a day, maybe not in a year, but Alok, I'm prepared to give it 3 years. Give it 3 years,
sure.
It can be thought about. So thank you very much. It's really been a wonderful discussion that we've had. Thank you to you, sir, for organizing this. And I hope you're able to take it forward. Thank you very much.
Thank you very much. Before Sumedha takes over, I'm deeply grateful to all of you for sparing your time and giving us the benefit of your experience. These are not idle comments, what you are making. All of you have spent a lifetime looking at these issues, understanding and fighting for change, and made a significant impact. Sir, we are deeply honored and we are very grateful for this learning. One request I would like to make of all of you and all the panels over the past 9th day today is we require your leadership and guidance over a long-term period. It's not merely FDR or some other organization, all of us together, Vidhi, many other organizations, Daksh, many others doing such intense work over the years. We all need to pool our resources, and we need your continued leadership and guidance to push the needle. I'm an optimist. I don't believe that India will go down the drain. I don't believe, however complex the problems are, we are incapable of solving them. They're not intractable. They're not beyond our capacity. But I have some experience and understanding of how change is managed in very complex democratic societies like ours. And if you do it right, and if you're non-partisan, if you bring all the stakeholders together, and if you don't have revolutionary solutions, but we have significant change effected by getting a consensus, much bigger change is possible. As I think Bill Gates said one of these days, and I completely concur with that, we always overestimate our capacity to bring about radical change in the short term. We underestimate our capacity to bring about big change in the long term. If we understand how to change the trajectory in the long term, it could be 3 years, could be 5 years, could be 10 years, the change is phenomenal. Oftentimes our impatience without wisdom is what is causing the problem. We in FDR and Lok Satta genuinely believe that the impossible best is the enemy of the possible good. And we have to aim at that possible good. And eventually there's always room for improvement. Each generation will bring about changes that are necessary in the country. And this field is incredibly important. That's the only thing where I would disagree with one of the panelists. I think Mr. Pai, well-meaning comment is, but I slightly disagree. You cannot simply say that the most important elites of society, in the best sense of the term, can be as bad as the societal distortions. They have to set the trend. They have to lead. They have to change the trajectory. They have to push the needle. And therefore, we have to make sure that our institutions, and the most important of them being the Supreme Court and the High Courts, they function far better to give us a better guidance of the country. Otherwise, we all go down the slippery slope and our democracy will be in peril. And I mean it very truly. All of us, I think most of us are the same generation, except maybe Alok seems to be a little younger.
Yes.
All of us, we belong to the emergency generation. We all grew up with the memories of emergency. My whole life is shaped by emergency and post-emergency events in the country. Otherwise, probably I would be doing something else, practicing medicine or whatever, anywhere in the world. All of us deeply care for our democracy, and we want outcomes, not merely the notion of democracy and doctrinaire approach that's necessary, but also outcomes for our people. And I think judiciary has an incredibly important role. We very humbly seek your guidance and leadership in pushing the needle over the coming months and years. I'm an optimist. I believe things can happen. They will happen. And this effort is one small little contribution to at least bring us together and bring a consensus. And today, as we can see, except on a couple of issues, there is an impressive consensus. That's what's remarkable. These 9 days have been a great learning experience to me, that there is so much that unites us, and we all believe roughly the same things. With a bit of a push and a nudge and a bit of strategic engagement, we can make big change happen. Thank you, sir. And Sumedha.
Thank you so much for this
Thank you.
opportunity, for being on this platform. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you to all the panelists for joining us today and for sharing your valuable insights. The takeaways from this discussion today will certainly guide us in our advocacy towards driving these reforms. And as Sir mentioned, we hope to have your continued support and guidance in the days to come. Thank you to all the participants as well who attended the session. The next session, which is also the final thematic session of this edition of the conference, is on judicial accountability and standards and will be beginning in 1 hour. Join us to listen to Justice B.N. Sri Krishna, Justice Chalameshwar, Dr. G. Mohan Gopal, and Shri Harish Narsappa as they deliberate on the mechanisms to ensure accountability and to maintain standards in our judiciary. Hope to see you all there. Thank you very much.
Thank you.
Thank you.